my presentation about the relationship between law and politics. Law and politics as social phenomena are two emanations of the same entity, monastic ontological conception, regarding which their separate existence is only a consequence of the human dualistic or pluralistic perception of the world, a dualistic ontological conception. Furthermore, the difference between law and politics from the deeper ontological perspective, in effect only illusory, for reason of which also in the field of legal and political theory and philosophy there are conclusions regarding the particular or complete overlapping of law and politics, sometimes even the equating of the two that raises a crucial questions of how both notions are defined. Regardless of such findings, the distinction between law and politics at the current level of human development is necessary and indispensable. With politics, it is necessary to distinguish three fundamental dimensions. Institutional dimension is expressed by the term polity and entails the operation of various regulated state and non-state institutions like political parties, social movements, public media and legislature, and the government. Normative dimension is expressed by the term policy and entails the creation of normative ideas or ideals that define basic social values and objectives geared towards a practical realization of such. Lastly, the process-related dimension is expressed by the term politics, which is expressed in the formation of the political will through the implementation of the social power and authority and built up through conflict and consensus. The relation between politics and law has both the progressive function and safeguarding function. Law and politics separately together both encourage and suppress the development of social relations, while they both also function to bring about justice and order. But law could not exist without politics, since politics gives law its driving force and its rough content or substance, which law then adapts to its autonomous framework and develops its final form, expressing it in a specific normative manner. Thus, one of the most demanding tasks of every society is to continuously attempt to establish and maintain appropriate balance between politics and law. This relationship is completely different in an authoritarian or totalitarian state as compared to a democratic state based on the rule of law. This is because in an authoritarian or totalitarian state, in the legal policy as a subordinate to the political policy. This is in a contrast to a democratic state where there is a dynamic partner-competitor relationship between two policies, where sometimes politics prevails and other times of the law prevails.
And who can enforce them? Just think about it. Anybody can create a policy, so those same people who created the policy can enforce it. But not just anybody can create or enforce a law. Legislators hold a special place in our government as lawmakers. Unfortunately, our common language of referring to legislators as, quote, policymakers instead of as lawmakers is transforming how we view government. Legislators are not policymakers. They are lawmakers. They create bills which become laws, laws that are then implemented by agencies through policies. To refer to legislators as simply policymakers implies that, number one, they somehow set the policy agenda or the slate of our values for the country or the state or the community, and two, that they can create policies or mandates or regulations that we all have to follow on a whim. Referring to legislators as policymakers takes the public out of the legislative process. We start to willingly comply with a social construction, as Schneider would say. Instead, if we refer to and recognize legislators as lawmakers, this recognizes the system of checks and balances involved in creating laws, otherwise known as representative democracy, and our separation of powers as outlined in the U.S. Constitution. By seeing legislators as lawmakers, we put the public back into government as the body who sets the values for the country or the state, and recognize that legislators cannot simply make laws on a whim. The deliberate use of language, as Stone would call it, is as basic as reclaiming legislators as lawmakers instead of policymakers. However, this deliberate use of language would also make the public, you and I, culpable in the lawmaking process. We would have to recognize our role in the laws we follow. We would have to grapple with the values propagated by society, otherwise known as us, and we would have to sit with the reality that making laws is a tedious, drawn-out, much debated, and public process by which we, the public, are constitutionally bound to participate in. So stop abdicating your throne in our representative democracy. Recognize the lawmaking process as one where legislators and the public are equally held responsible. Connect your displeasure with the legislature to an identifiable agent, you. If you disagree with this, then I offer you one option. Just eliminate legislators entirely and simply write a computer algorithm for decision making. You will answer a brief questionnaire, input it into the computer, and it will render a decision. Not a good idea? Well, let's just leave it up to the courts then. But judges are not policymakers or lawmakers. They interpret the laws and make decisions about cases before them or about decisions made in other courts. However, some people argue judges are both policymakers and lawmakers. They say we have two legislative branches of government. This view is where the belief in a democratic republic comes from. Yes, we do have a supposedly representative democracy, but those who see us as having a democratic republic view that we actually have rule by law rather than by the people. You see, the difference between policy and law is not just semantic. It does shape how we view the role of government, and it exposes what we as the public have decided holds the most power and influence over our lives. Think about it. What has more power and influence in your mind, policies or laws? I'll vote for policies for two reasons. Number one, policies implement the laws and make them real. Two, we all make public policy happen, public servants and stakeholders alike. Policies are just one of many tools to carry out decisions. They are the tools of our governance. However, policies may or may not be the right tool for the job. For example, if I want to get speed bumps installed in my neighborhood, I can go through the traffic calming program and follow their policies. However, if I want to get the speed limit reduced in my neighborhood from 25 miles per hour down to 15 miles per hour, I need to go through the city council to change a law. The scenario is the same no matter which tool I use. The problem identified is that people are driving too fast through my neighborhood, and the outcome I want is to get people to drive slower. But the consequences are drastically different. The policy approach hopes to alter drivers' behavior with the intervention of speed bumps. The speed limit law change gets at altering drivers' behavior with the possibility of punishment for not driving at the new speed limit. The point is, be sure to end up with the right tool for the right solution. A law can often have more teeth than a policy, but a policy may be easier to implement.